Everyone to Maxwell Conversations, featuring conversations with high-profile international arbitration lawyers on international arbitration topics that challenge assumptions with a deeper examination of the issues. Parties to arbitration agreements refer their disputes to arbitrators with a range of expectations as to arbitrator behavior. Often, these expectations are formed without much consideration of the arbitrator's precise legal status. Assumptions range from arbitrators having a contractual relationship with one or both parties, or with the arbitral institution, to arbitrators having a status conferred by law and convention. Some regard arbitrators to be private judges, while others regard them to be facilitators of settlement of the dispute. Missed expectations sometimes arise as to arbitrators' responsibilities in relation to the application of the law, delegation of work, and articulation of parties' cases. In this fourth conversation, my guest is Bernard Hanotiau, who has since 1978 been appointed arbitrator in more than 500 cases. He holds emeritus and visiting professorships in Belgian and Singapore universities. He's a member of the ICA Advisory Board and the ICC International Arbitration Commission, and he is author of many articles and also the book Complex Arbitrations, Multi-Party, Multi-Contract, Multi-Issue. We will later be joined by two other guests, BC Yoon and Elodie Dulac, as we go more extensively into the duties of international arbitrators. Bernard, welcome. You are very well known in international arbitration. Let me start off this talk by asking you to tell us what has occupied your time in the last 2 years.
Well, first, Laurence, I would like to thank you and to thank Maxwell Chambers to have invited me to this fourth edition of Maxwell Conversations. Well, what I have been doing recently, I've been doing what I have done for the last 45 years. I've devoted all my professional and academic career to international arbitration. And that is what I continue to do, sitting mainly as arbitrator, but doing also some limited work as counsel, delivering legal opinions, and participating as speakers in webinars and seminars. And I must say that I'm very happy that the pandemic is progressively over and that we are able again to have hearings in person, and that I'm able to travel again all over the world, and in particular to Singapore, my favorite destination.
That's good to know. If I could turn to our conversation today and go first to the precise legal status of arbitrators, and by that I mean the legal source of their position. When parties go to litigation, they do so before a judge whose status and role is established and defined by national laws. Yet when it comes to international arbitration, one finds that while there are provisions on the constitution of tribunals, challenges, jurisdiction, and conduct of the proceedings, hardly anything is said by these conventions, national laws, or arbitral rules about the precise legal status of arbitrators. Why do you think, Bernard, that this is the case?
Well, it is true, Laurence, that there is very little in legislations, conventions, and arbitration rules on the legal status of arbitrators. I have asked myself the question, why is it so? And my answer is probably, first, that it is probably not indispensable, and secondly, that it is probably too complex. Let me explain that. Well, the position of arbitrators is totally different from the position of national judges. The judiciary is a very important part of the state machinery. In each country, there is a very complex structure of tribunals, a very complex hierarchy of judges, and therefore it is indispensable to organize all this, to determine the conditions for a judge to be appointed, to be promoted at each level of the hierarchy, to determine their territorial and material jurisdiction, how they are going to be remunerated, etc. Arbitration is totally different. There is no permanent arbitral tribunal. There is no hierarchy. The jurisdiction of the arbitrator is determined on the basis of the arbitration clause, or in the investment arbitration on the basis of the terms of the treaty. So one may ask oneself the question, if national legislators were to legislate on the status of the arbitrators, what should they put in their legislation? The appointment, the arbitrator is appointed for one specific case at the difference of national judges. His place in the hierarchy? There is no hierarchy in the arbitration world. The term of service is just appointed for one case. Or is going to be remunerated? This is a matter of agreement with the parties and eventually an institution. Is obligation of independence and impartiality? This is already included in the laws. So in other words, I'm not sure that there is much to say on the status of an arbitrator and the difference of the status of a judge. A legislation on the status of an arbitrator might end up in general principles that the arbitrator has obligations which derive from his mandate of adjudicator and obligations which derive from his contract with the parties and eventually with an institution. The rest is already contained in the laws on arbitration. Moreover, I see a particular difficulty if national legislators were to legislate on the status of arbitrators. There might be difficulties at the level of the applicable law. What is the law which governs the status of an arbitrator? One may wonder, for example, what would be the applicable law to the status of a Singapore arbitrator sitting for practical reasons in the United Emirates, while the place of arbitration is Kuala Lumpur? Would his status be governed by Singapore law, the law of the Emirates, the law of Malaysia, or the three of them? We might end up with an arbitral tribunal whose three arbitrators are subject to a different status. So in other words, I'm not sure that there is a need for a legislation on the status of arbitrator. And if there was such a need, it should preferably be elaborated at the level of an international organization such as Arbitral or the International Bar Association.
Thank you. The result of this position is that it is left to national courts and academic commentators to develop theories on the precise legal status of arbitrators. And one of the most widely accepted theories, which you've referred to as well, is the contractual theory, where it is reasoned that the arbitrator or arbitrators and the parties enter into separate agreements with one another by which the arbitrators agree to perform specified functions in return for remuneration, cooperation, and arbitral immunity. Do you see problems with this kind of contractual theory, Bernard?
Well, I think that the contractual theory is too narrow. It is true that the setting up of an arbitration, in the setting up of an arbitration procedure, there is a succession of consents. Consent between the parties who agree on an arbitration clause, then consent between the parties and the arbitrators when the arbitration is put in motion, and eventually consents to adhere to the rules of an institution. It is also true that arbitrators have obligations that derive from their contract with the parties and eventually with the institution. So in other words, the contractual theory makes sense. But it is not sufficient, in my opinion, to explain the globality of the function of an arbitrator. And in this respect, I would like to make two remarks. First, it is clear that the contractual theory does not answer all questions. What is the law which governs this contract? What are the terms of this contract? Very often it is not put in writing. And in particular, it does not answer the question of the nature of the contract. Is it an agency agreement, a service agreement, or another type of agreement? So in other words, the contractual theory is limited to general principles and does not answer many questions. But is this very important? Does this lack of specificity have a direct impact on the day-to-day functioning of an arbitral institution, of the arbitral institution? I'm not sure. My second remark, why the contractual theory is insufficient to explain the role and function of an arbitrator, is that the consents which are exchanged in the arbitration process, and on the basis of which we say that there is a contractual theory, are not efficient per se. They would not be efficient if they did not find their source in the laws on arbitration, which enable the parties to set up a tribunal and give the tribunal the power to decide the dispute at the exclusion of national courts and give the awards binding force. In other words, the contractual theory puts the emphasis on the fact that arbitrators have obligations that derive from their contract with the parties and eventually an institution, but it is insufficient to explain in its globality the function of the arbitrator, who also has important obligations that derive from its mandate of adjudicator conferred to him by the relevant arbitration law.
Thank you. Another theory that has been offered is that the precise legal status of arbitrators is not contractual because of the arbitrator's adjudicatory function, but based on the arbitrator fulfilling a mandate conferred by law to which the parties agree. Would you say that there are also problems with this kind of theory?
Well, I think that both theories are not exclusive, one from the other. They are complementary. As I've mentioned, there is definitely a contractual relationship between the parties and the individual arbitrators. But the contractual theory does not reflect another essential role of the arbitrator. He also has mandatory obligations that derive from his mandate of adjudicator conferred to him by the relevant arbitration law. Arbitrators are appointed by the parties, but they exercise a jurisdictional function, a jurisdictional mandate by virtue of that law. And if the parties can set up a tribunal to settle their potential disputes, it is because the law entitles them to do so. And this authorization to set up a tribunal is implemented by the parties in the arbitration clause. And once the dispute arises and the arbitrators are appointed, it is further implemented in a contract with the arbitrator, which can be eventually formalized in terms of reference or terms of appointment. But, and this is a very important point, such a written contract is not absolutely necessary. The procedural effect of the implementation of the arbitration clause, the procedural effects of the implementation of the arbitration clause are usually predetermined by the law on arbitration without further contractual provisions being indispensable. Once the arbitration clause is put in motion, the law on arbitration predetermines what has to be done: appointment of arbitrators, appointment of a chairman, acceptance by the arbitrators of their mandate, potential challenges, hearing, award, etc. In other words, the arbitration contract between the parties and the arbitrators is a contractualization of the relationship, the arbitration link between the parties and the arbitral tribunal, as defined by the relevant law on arbitration, together with amendments to the extent permitted by that law. And this contractualization includes a lot of procedural steps, but also a restatement of the obligations imposed to the arbitrator by virtue of his mandate of private judge. So in other words, you cannot only explain the role of an arbitrator by the contractual theory, it has also to be rationalized on the basis of the other theory, based on the fact that the arbitrator is fulfilling a mandate conferred by law with all the obligations pertaining thereto and to which the parties agree. Both theories have to be resorted to explain the full role and function of an arbitrator, who is not only a contractual partner, but also an adjudicator by virtue of the law on arbitration.
Bernard, what you have said in a very learned and thoughtful way refers to what is an unwritten contract or largely unwritten contract, which takes place in the background of laws and conventions. It is a way to resolve this quandary about what the theory, the appropriate theory should be. But do you see issues or problems, either from a civil law perspective or common law perspective, in the parties knowing for certain what the precise terms of this agreement or mandate might be?
Well, I think that the legal mandate of the arbitrator is clear. He is a judge. Like a judge, he must be independent and impartial. He must decide a dispute in full compliance with due process and the principle of equality and in an efficient manner. This is a universal principle and nobody will ever dispute this. So in my opinion, the mandate is very clear. Moreover, the laws on arbitration detail all the steps that have to be taken from the moment the arbitration clause is put in motion until the rendition of the award. And it is by virtue of that law that the parties are authorized to put in motion an arbitral procedure leading to a binding decision of their dispute as long as there is full compliance with the fundamental requirements of the law of fairness and justice. And I do not think that it is difficult to explain, as sometimes parties have said, commentators have said, it is not difficult to explain the right of remuneration if you refer to the theory according to which the arbitrator fulfills a mandate conferred by the law. Arbitration is another type of justice. Judges are paid by the state. Arbitrators are paid by the parties. I think it's a general principle of international law that arbitration is onerous. The best proof of that is that some arbitration laws even contain entire sections on the cost of arbitration, and most of them have a few provisions on the allocation of cost in the award. So I think, in my opinion, the legal mandate of the arbitrator is quite clear.
You also mentioned earlier that depending on the approach or the theory applied, some problems could arise. For example, what is the applicable law to the arbitrator's appointment? Do you think personally that the precise legal status of arbitrators needs clarification? And should this be done or supplemented by conventions, national laws, and arbitral rules, or indeed by some of the institutions that you mentioned earlier?
No, as I said, I do not think so. I don't think it is indispensable. It might even give rise to some difficulties. And I think there are enough regulations on arbitrations at all levels. We do not need another piece of legislation or guidelines on the status of arbitrators.
So in your view, it is enough, or there's enough of a legal basis, let's say in an ad hoc arbitration where an arbitrator fails to receive remuneration, for the arbitrator to have a legal basis to claim for his or her fees?
Yes, well, even if in an ad hoc arbitration, there will be an agreement of the parties on the remuneration of the arbitrators. I think the right to a remuneration, as I said, is something which is a basic principle of international law, and I think that nobody will dispute this. And even in an ad hoc arbitration, although even if there is no agreement, written agreement between the parties, there will be some rules established, for example, in a procedural law, in a procedural order, and in which, for example, the parties and the arbitrators will agree on the remuneration. And you know that the basic rule in this respect is that in principle, in ad hoc arbitration, the fees have to conform to the ordinary rules of remuneration in that particular jurisdiction. So for example, if there is an ad hoc arbitration in Singapore, the parties have to comply with the ordinary rule of remuneration in Singapore, and the reference will probably be the schedule of fees of SIAC.
Bernard, would you also speak to the position of arbitral institutions in an institutional arbitration? Do they fit somewhere in a contractual theory in the sense that the arbitrator also has a contract with the arbitral institution, or do they fit perhaps in the legal or conventional theory that's been applied to the position of arbitrators?
Well, as I said at the beginning, there are various consents in the arbitration process. First, a consent between the parties to agree on an arbitration clause, then a consent with each arbitrator who accepts his mission as arbitrator, and then eventually a consent with an arbitral institution. And the arbitral institution undertakes to manage the case, and the arbitrators agree to abide by the rules of the institution, but the institution also undertakes to pay fees to the arbitrator. And separately, there is also an agreement between the parties and the institution. So in fact, this is the basis of the contractual nature of arbitration. There is a succession of different contracts, including a contract with an institution.
Thank you very much, Bernard. If I ask you to stay on, we are now joined by two other guests. The first is BC Yoon, a partner at the Korean law firm Kim Chang. He is part of the International Arbitration and Cross-Border Litigation practice and a leading practitioner who has served as a court member of the ICC Court, the SIAC Board, and currently at LCIA. BC is on the panel of arbitrators of many institutions and also plays a key role in promoting Korean international arbitration through KCAB and Seoul IDRC. The second is Elodie Dulac, based in Singapore at King Spalding. Elodie has represented clients in both commercial and investment treaty arbitration around the world, with a particular focus on Asian and Asia-Africa disputes. She sits as arbitrator has been appointed arbitrator in HKIAC, ICC, SIAC, AIAC, and ad hoc arbitrations. BC and Elodie, welcome. Elodie, assuming the contractual theory to be the correct one, with whom do you think the contract is made? And I've asked Bernard about this, but I'd like to know your views, assuming the contractual theory is the correct one.
Thank you, Lawrence. Well, I think as Bernard described very well, it's there is no straightforward answer, but there is a web of relationships. I think, as you said, like national laws are usually silent about how the relationship is to be defined, and courts in a number of jurisdictions have given views on this. So if you take the contractual approach, I mean, there is, of course, starting between the parties and the arbitrators, and assuming there will be one contract with the arbitrators and not three contracts, if it's a three-member tribunal. For instance, the English courts have taken the view that the arbitrators will become party to the arbitration agreement. So it will become a three-party relationship. A probably more widespread view, and that has been the view of French courts, have been to view this contract between the arbitrators and the parties as a separate contracts, which would arise when the arbitrators accept their appointment after being approached by the parties. Whichever the case may be, this arbitrators agreement will incorporate anyway the terms, the framework from the arbitration agreement, be the seat, the arbitration rules, if any, the language of the arbitration. I mean, the arbitrators agreement has to match the content of the parties' agreement. There needs to be consistency. And then when it comes, like Bernard alluded to it, and the characterization of this contract, I think it's preferable to view it as sui generis, because if you look at it, bottom line is the arbitrators have to be independent. So agency wouldn't fit because the arbitrators are not representing the parties. I think English courts have rejected the employment contract characterization because, of course, the arbitrators are not like subordinate or of the parties. Similarly, a service contract where you would have instructions by the parties to the arbitrators wouldn't fit. So characterization sui generis, with the arbitrators being independent from the parties, is more suited, I would think. And then, so there is this relationship, arbitrators, parties, and then if it's an institutional arbitrations, then relationship between the arbitrators and the institution, separately from or in addition to the relationship between the parties and the institution. I think that relationship as well can be viewed as contractual, with the arbitration institution approaching the arbitrator about the appointment, and if it's accepted, the arbitrator would accept usually and sign the appointment, the acceptance form. In a way, it's actually maybe more formal than the acceptance with the parties, which may be less in writing, especially if there are no terms of reference, no terms of appointment. With the institution, arbitrator sign the terms of appointment, the acceptance form, and that would give rise to an agreement, the institution agreement, if we may call it, to distinguish it from the arbitrator's agreement. But in the end, and all these agreements have to be consistent, obviously. If there was an applicable law to search for that, that would be the thorny point, and as Bernard alluded to it, and whether it would be a conflict of laws approach, and then you can, how do you characterize a contract, and are you going to go back to the seat and taking a very territorial approach? I think in most instances you don't get to that, but that would be like a second layer of difficulties once you have this agreement in place, is do you need to look for a law applicable to them?
Thank you. BC, may we know your views on the contractual parties to the contractual theory, assuming it's the correct one?
Yes. Before we go that, I have one observational comments on Elodie's the comment. So I think there can be, but by accepting being appointed arbitrator and the parties enter into an arbitrator's agreement, and even if when the authorities, appointing authorities in the hands of the institution is having some power of attorney and appoint the arbitrator on behalf of the parties, then who are the party to the arbitrator's contract? The parties and arbitrator, and the parties and institutions. And in some extreme situation where the party failed to make payment to arbitrator's fees, and institution failed to make payment to the arbitrators, where the arbitrator can seek a claim or compensation from the institution, whether there exists a contractual relationship. So that is one point I would raise. And coming to your question to Lawrence, the nature of so you asked how the nature of the arbitrator's contract would affect the parties' expectation, especially with respect to the co-arbitrator's role. So I think the contract theory is providing that there some jurisdiction is saying that is an employment agreement, and also it is an agency agreement or service agreement, and that could have some implication with respect to parties' expectation vis-a-vis the conduct of a party appointed arbitrators. And the party may expect that the arbitrator to follow their directions. Easy directions are agent appointed has to comply with the term which they have agreed to, and if not in breach of the contract, if they exceed the authority on one hand or fail to carry it out on the other. As a result, under a strict application of those theories, party may expect that the party appointed arbitrator may even act as an envoy or mouthpieces. And there are some leniency in arbitration, domestic arbitration in some jurisdiction on the neutrality of the party-appointed arbitrator. However, no such leniency exists in absolute requirement of impartiality and independence when in this international arbitration area. So that's pretty clear. But when we talk about the role of a party-appointed arbitrator, the real issue is while they cannot be an advocate of the appointing party, they are expected to fulfill a positive and useful role for the party appointing them. For example, they are expected to assist the balance of the tribunal or party by directing questions for the sole purpose of enabling a proper understanding by both the tribunal and the parties of those aspects on which there is a apparent difficulty. However, it is not improper conduct to direct the parties by questions to matters which the party tribunal perceive as important and require clarification. If there is a clear bias in the co-arbitrator's behavior or a lack of impartiality and independence on the part of party-appointed arbitrator, which cannot be corrected or negated, then there are challenges and removals. But that is the rule we are talking about. So that is the current legal framework that could be supported by contractual theory, or that could also be supported by the mandate conferred by law theory. So I will pause here and thank you.
Thank you. We'll come back to the agency approach to the role of arbitrators in a minute, but I'd like to invite Werner to comment on 2 points. One, Elodie's reference to the contract between arbitrator and the parties being sui generis or one of a kind. And the other is to BC's comment that wondering whether there is indeed a legal basis for an arbitrator to make a claim for unpaid fees, either against the institution or against parties. Werner, would you care to comment on these 2 points?
Yes, well, there's been a lot of discussions on the type of contract, which is the arbitration contract. What is it, in fact? Is it an agency agreement? I don't think so, because the arbitrator is independent and impartial. He cannot comply with the directives of a principal. Employment agreement, definitely not, because it implies a link of subordination. And then a service agreement, well, not really, because it does not take into consideration the adjudicatory role of the arbitrator. Although I read recently a French decision saying that and you know, they were discussing the territorial jurisdiction of the court, and they said the arbitrator is part to a service agreement. But basically, I would say that, and I agree with Elodie, it's a sui generis contract. You know, it is obvious that the arbitration contract is not an ordinary contract. For example, in an ordinary contract, if a party does not deliver the goods that it has promised to deliver, or a party does not pay the goods for which have been delivered, well, they can terminate the contract and claim for damages. Well, in arbitration, it's totally different. The sanction will be procedural. If a party does not pay the advance on fees, and the other party does not pay the advance, then the arbitration will not proceed until the advance is paid. So the consequences here will be procedural. So it is obvious that the arbitration contract is a totally different type of contract. Then can you sue the institution if your fees are not paid? I think, yes, you could. Well, I have had only one case with the American Arbitration Association. They forgot to ask for an advance, and so the fees were not paid. They said, we're going to sue the party. We are going to ask Dun & Bradstreet to sue the party, but I've never heard of anything, and I've never been paid. But I think that you could definitely sue the institution because you have a contract with the institution.
Thank you. BC, you spoke a little bit earlier about some parties regarding their contract with the arbitrator to be some sort of agency or employment agreement. And we've heard views from Bernard that he doesn't think that an agency or employment approach to the contractual theory is the correct one. I guess my question to you is, assuming that parties still adhere to this view of an agency or employment contract, could this give rise to problems in the expectations of the parties as to arbitrator conduct? I think you mentioned arbitrator impartiality or bias a little bit earlier, but perhaps you would like to expand on that.
Yes, I think that a better view on the nature of the arbitrator's contract is a sui generis contract, given the judicial function or the mandate conferred by law. But given the traditional, more prevalent, and in some jurisdiction like Switzerland, the agency theory, or in some jurisdiction, even as employment contract. And so that would create some expectation by the parties. And that could, these days, the parties are bringing lawsuits for in some jurisdiction. So there is, when we talk about the liability and the immunity issues, so parties' expectation on not only on the co-arbitrator's role during the conduct of the arbitrators, when they talk about the liability and the immunity, I'm wondering whether that would affect, how that would affect. So I think from casually thinking, I think if the nature of the contract is the agency or contractual theory, then I think party may, I think the party may more likely think that the liability may be more easily sought and the scope of immunity may be smaller. But I think under the different theory that like US, or then for public policy consideration, larger immunity could be created. So I think that is additional my comment on the expectation, how the nature of the contract would affect the parties' expectation, and what is the better view on it. So I think it seems a better view seems a sui generis theory, because it is not merely a contract theory. And so for various policy consideration, there are the immunities granted by the national courts. Thank you.
Thanks. Elodie, I'd like you to comment on that and perhaps ask you the pointed question. I mean, if the parties have an agency or an employment contract view to the appointment of arbitrators, wouldn't that naturally lead to an expectation that an arbitrator is supposed to do a job that is perhaps partial to the party appointing him or her?
Yes, and I'm not sure, I mean, when I've experienced this view by the parties, it wasn't that much theoretical. It was, well, we appointed him or her, and he or she is a hired gun. So I think that's where the council have to come in to explain the role of the co-arbitrators, and that and the independence. And I think usually parties are receptive to it and understand it. And actually, I mean, I think in my experience, when co-arbitrators haven't been, obviously not independent, and parties actually haven't liked, my experience, haven't liked it because it's counterproductive. It's very obvious. It's a loss of credibility for the co-arbitrator. So I think I haven't seen parties approaching it at a theoretical level. When there has been a misunderstanding about the role of the arbitrator, it has to be very diffused by the council very early on about what exactly that person role is going to be and the independence. And so the parties are not taken aback if the co-arbitrators start asking questions at a hearing, which are not unhelpful, which happens.
Yeah. Bernard, do you think, in the light of what BC and Elodie has said, that there is a greater need to either articulate or repeat the need for impartiality, or to harmonize it under some model law or soft law, so that everyone is clear that an arbitrator, and in particular a party-appointed arbitrator, is not carrying out the agenda of the party appointing him or her?
Well, let me add that, in my opinion, the notion of independence and impartiality, although I'm very clear on that, but sometimes it's very cultural. I'm not going to mention any nationality, but there are some people in some regions of the world who consider systematically, when you have them as co-arbitrator, systematically, they consider that they are some sort of advocates of the party that appointed them. Once I had an arbitration in Syria, and the co-arbitrator, each time we had a difficulty within the arbitral tribunal, procedural problem, he said, I must first speak to my party. Okay. And so at the end, when the award was issued, and of course he did a dissenting opinion, he said, I'm really sorry for my conduct, but you know, the guy who concluded the contract is in jail. And if I had not acted as if I had, as I had done, I would be also sent to jail. So, you know, there are certain elements which I would not say justify, but which explain the attitude of some parties. Normally, I think the institutions are very clear, the literature is very clear what you can expect from an arbitrator. He has to be totally independent and impartial. Sometimes I even forget who appointed me. But in some regions of the world, there is a tendency indeed for some arbitrators to act a little bit as advocate of the party who appointed them.
To add a little bit of context before we go into the question and answer section of this event, I'd like to ask you, Bernard, about what happens behind closed doors. I'm sure many in the audience will be interested to know what typically happens when a tribunal retires to determine a dispute after having heard the evidence. Your experience and your insight will no doubt be valuable to members of the audience. Would you speak to that a little bit?
Yes, if I'm too long, you just cut me, because I think I have a lot to say about that. Well, first I will start with the role of the president of the arbitral tribunal. I would say that he's to some extent the general manager. He's the one who makes the proposal concerning the organization of the proceedings. He's the one who will make the first draft of terms of reference, of procedural orders, of decisions on requests for document productions, on decisions on incidents of procedure, and very often also he's the one who is going to make the first draft of the award. Of course, all the time in full conjunction and cooperation with the co-arbitrators. My experience of several hundred cases is that generally the atmosphere within the arbitral tribunal is quite convivial, and very often there is unanimity of views, including concerning the decisions to be made in the award. But it is not always the case. So you have a first scenario where the two co-arbitrators have totally opposing views concerning the decision to be made in the award. I think in this case, the chairman of the arbitral tribunal has to be extremely diplomatic. You should listen to your co-arbitrators. You should avoid to immediately express your personal views. You should rather ask questions and try to understand why they have these different approaches to the case. With a high level of diplomacy, I think you can reach very good results. Let me give you one example. Once I was sitting in Paris with two prominent law professors. They had two different opinions on the issues to be given to the case. And I told her, well, at the end, I expressed my provisional views very diplomatically. And I said, okay, I'm going to be away for 2 weeks. You both live in Paris. Why don't you meet and try to see if you cannot, agree on, minimize your differences? They did. And after 2 weeks, they reported they had made some progress. And I said, okay, no, I have another hearing, 2 weeks. Why don't you try again to try to reach an agreement? They did, and finally they reached agreement. One of the co-arbitrators was a bit reluctant, but finally we had a unanimous award. I always try also to convince an arbitrator who is not in agreement with the majority not to write a dissenting opinion, because I think it could fragilize the award. So what I suggest is to try to convince this arbitrator to accept that we mentioned in the award that it is a majority opinion, or the other possibility that there be some mentions in the award that on a particular question, the majority has made such decision, but an arbitrator had a different opinion, which is summarized. One more critical situation, of course, is where you have very partial arbitrators. It happens. It happens not very often, but it happens. Well, generally, there is not much you can do about it. I've seen rarely cases. I've seen a few cases where the chairman has made an admonition to this arbitrator. But what happens, in fact, in practice, in most cases, is that the views of these arbitrators are not going to be taken into consideration or largely taken into consideration by the two other arbitrators. If I still have time, let me make two other points. First, how do deliberations take place? Well, there are various scenarios. In most arbitrations, it is a progressive process. Sometimes already at the very beginning of the arbitration, but generally rather in the course of the proceedings at each break, the arbitrators express their respective views. It is very useful because sometimes there is something that one arbitrator has seen and others arbitrators have not seen. And so progressively, the arbitral tribunal forms a view on the decisions to be made on the various issues. And very often at the end of the arbitration, the tribunal is in agreement on all points, on most points. But on the other hand, there are very complex cases like huge construction cases or investment cases where the issues are so complex that further deliberations are necessary. And there you have two scenarios. In the first scenario, the tribunal agrees that the president, the chairman of the tribunal, the chairperson of the tribunal, will make a first draft, and then the parties will deliberate on the basis of this draft. The other scenario, the members of the arbitral tribunal set aside 1, 2, 3, 4 days, sometimes 2 weeks, to deliberate in person. And if I have time, I make a final point. Should arbitrators help the parties to settle their dispute? Well, it really depends upon the jurisdiction. I'm told that it might be problematic in England. On the other hand, if you are on the continent, in Belgium, in France, or even more in Switzerland or Germany, where it is very common, it is not unusual for arbitrators to encourage settlement. And I have done it several times. Let me give you two examples. In one case, at the initiation of the hearings, the three arbitrators said, this is really, it was a high value case, but the three arbitrators said, well, this is really a case where the parties should settle. And one of my co-arbitrators was a German mediator. He had a lot of experience on mediation. So we proposed a mediation to the parties. We did the mediation, and you can believe me, at midnight the same day, although it was a high value case, the parties settled. I have had cases also where my tribunal has proposed to the parties in Switzerland, in both cases, towards the end of the arbitration to give them its provisional views, to assist them to reach settlements. These were cases where, you had a dispute on shareholders' agreements, but the parties had a company, a manufacturing company, and whatever the solution to the dispute, they had to continue to work together. So we thought it was important to try to help them reach a settlement. And we gave them our provisional views. The parties agreed to try to settle. They undertook never to refer to this process in their posti in briefs if the settlement negotiations were not successful. They also agreed not to challenge the arbitrators on the basis of the fact that they had expressed their preliminary views. And in both cases, it took a certain time, but the parties settled.
Thank you, Bernard. BC, I'm going to invite you to comment on what Bernard has said and perhaps ask you whether, in your own experience of what goes on when a tribunal determines a dispute, you have had similar experiences, or perhaps certain styles which are different because of a cultural approach may apply.
Relating to the settlement, your question.
Yes.
I see. So I think the parties' expectation when we go to arbitration, the expectation is that the parties are going to arbitration since they fail to settle it amicably. So I think it would be in principle expectation that the tribunal will conduct the arbitration in a adjudicatory manner and render decision. But there are, as Bernard mentioned, when you actually hear the case, then I think nobody can fully get what it originally wanted. And then I think that could lead to a situation that the tribunal may, based on the arbitrator's duty to adjudicate, they may think it is reasonable to suggest mediation. Or even the counsels, there are a situation that the counsels, when the clients are very important and the amicably settling the case could be also a good way of managing clients' relationships. And since in view of the possible legal fees expected, if the stake is not that guaranteed or that large, then I think it would be also mutually good way for each counsels to resolve the disputes in amicable way. So in that case, the counsel also has a duty or in their checklist that to consider. And I think while hearing from Bernard, I thought of the idea of appointing one good experienced mediator as an arbitrator, who also have both skill sets to arbitration, to the tribunal. Could be also one doable approach. Thank you.
Elodie, Bernard mentioned earlier that determination may involve a more elaborate process where the issues in the arbitration are complex as opposed to when the issues are simple issues. He mentioned, he made a reference to construction contracts, for example. In your experience on complex issues, is there a tendency that one of the arbitrators who starts off articulating his or her views in an extensive way may influence the rest of tribunal thinking?
Well, I would say that's something I'm very careful about when I'm a chair. And when you realize one of the co-arbitrators is very much prepared, like on top of things at some point than the other one, and may even start putting things in writing and to try and maintain a balance. I must say, well, if I'm a chair and well, if I'm co-arbitrator, I want to make sure all voices on the tribunal are heard, and actually I would be more cautious and myself, like questioning myself more if one of the co-arbitrators are very like expresses view pretty early on and sometimes even before the hearing about the outcome. So I think that there needs to, I definitely seen, I mean, as counsel, I think I guess there have been instances where you do see that one co-arbitrator was very prepared or more knowledgeable about the area, or if it's a complex issue, it may be technical, like maybe accounting damages, where some arbitrators are more versed or more prone to get deep into these issues than others, and that definitely can become a disadvantage. I think when I sit as an arbitrator, I'm very cautious about that. When I'm a counsel, I'm very nervous about that.
Thank you. Ladies and gentlemen, we now come to the question and answer part of this event. If you have a question that you'd like us to consider for answer, you may use the question and answer function to pose it. That is really a formal announcement. We have more than enough questions coming in. And one of the questions that has come in, which shares a lot in common with other questions, which I would like to put to the panel of speakers, is this. Is there a duty for arbitrators and arbitral tribunals to deliver justice? How can there be proper justice when arbitrators are appointed by parties according to their wish, even though in theory they try to, or they must be independent and impartial? How can this be assured in the minds of the arbitrators, the lawyers, and the parties? So, to me, the question is a question also of whether it is the function of an arbitral tribunal to deliver justice as litigants in court know it, or is the arbitral tribunal's role to deliver a result that is acceptable to both sides? Perhaps we can start with Bernard.
Yes, well, it is a question which is very often raised, and there are different approaches to this. I think that, although I'm very cautious when I say that, but I think that in the United States, for example, the idea is that the arbitrator must render justice. I think that the arbitrator, he must deliver an award on the basis of what it has received from the parties. So he should not go beyond what the parties are asking and what the parties are arguing. And in this respect, and I recently, well, 2 years ago, I made a presentation on this, and I discussed this issue with other arbitrators. For example, in the course of the procedure, one party does not raise an important argument, which could be determinative of the case. I've been confronted to this very often. And let me give you one particular example. I was co-arbitrator, chairman, former Canadian judge, and a Swiss arbitrator. In Switzerland, you have the principle jura novit curia. So in other words, you may address issues in the awards, even if they have not been raised by the parties, as long as this argument could have been anticipated by the parties. And you can raise also these arguments during the procedure. And in my particular case, the Swiss arbitrator at one point, and it was at the very end of the hearing. He said, but claimant did not invoke this argument. I said, yes, he did not invoke this argument, but too bad. He said, no, 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 I'm a Swiss arbitrator, I must raise the argument. I said, you cannot do that, because it is true that it is a very good argument, but he did not raise it. And the chairman was also of my opinion, but he raised the arguments. And of course, the claimant immediately, realized that he had forgotten this argument. And in the post-hearing brief, there were long developments on this argument. Well, I think personally, and I know that a lot of arbitrators share my views, I think a majority, you should not raise an argument which has not been raised by the parties. You do not have to help one party to win or to lose. So this is, one way of seeing, should you render justice? No, I think that you have to decide the case on the basis of the arguments which are submitted to you by the parties.
Thank you. Elodie, it's often been said that the role of a party-appointed arbitrator is to ensure that the tribunal as a whole understands fully the case of the party who appointed this party-appointed arbitrator. Do you subscribe to that thinking, that it is part of the role of a party-appointed arbitrator?
Yeah, I mean, that drawing the line, it's not to promote or to help that case. It's to maybe to clarify it if needed. Sometimes it's not needed. But if we agree with Bernard, like what Bernard just said about raising new arguments, and have had the experience of like co-arbitrators coming up with arguments, helping their party, which hadn't been raised by that party. And that's where it's not helping the case of the party. But I would say, I mean, sometimes both sides, the other side may need things to clarify as well. I think a co-arbitrator would also want to understand the case of both parties, not only his parties, but it's like being kind of a safeguard if the case is not fully understood the way he understood it, or to make sure the case of his party is heard, but no, not more than that.
BC, do you think that this is a valuable distinction, or is it simply a disguised way of saying that the party-appointed arbitrator should put it simply, help the party when the tribunal deliberates?
Yeah, that's very fine line. And the beauty of international arbitration, although some renowned arbitrators says that the party appointing authority should be removed and all three should be appointed by institution, but the parties, if we see the survey of Queen's University, Queen Mary University, the party's appointment of arbitrator is a very big factor of attraction of international arbitration. But also we see our clients somewhat disappointed when, even though they were very impressed by the arbitration in front of a respected arbitrator, but when one of the party appointed arbitrator are going to the sensitive area, that the division between raising the issues to have the other arbitrator understand the issue or suggest the argument that has not been raised by that party or was even hinting at. So when the arbitrators are going to that dangerous area, the parties are also very easily catch that, and some are disappointed. So I think that I fully agree with Bernard that the justice means procedural justice. If you say that you have a duty to deliver procedural justice, but substantive justice could be somewhat subjective one, depending on which party you see that case. The justice could be different. So infra petita or supra petita or beyond the scope, the tribunal can rule on it. So that kind of procedural rule or the fairness attitude should be the basic rule that our players should adhere to. Thank you.
Another question that has come in, which is representative of the same or similar kinds of questions that we've received, has to do with civil accountability of the arbitrator. I'm going to ask Bernard whether he sees that parties or arbitral institutions are increasingly demanding more and more accountability from the arbitrator, and if so, whether there's going to be a trend where that is the expectations of the parties, that when an arbitrator is appointed, whether it's by the institution or by the parties, the institution or the parties would hold the arbitrator accountable for his or her actions in an arbitration. Bernard, what do you think?
Yes, well, what I see, especially in France, for example, when the liability of an arbitrator is put in question, is generally because of a lack of disclosure, and the impact of this lack of disclosure on, his independence and impartiality. The approach of various countries in this respect is stricter or less strict. I think that the right balance has been reached in England. They're very realistic in their approach. In France, they're very, very strict in that respect. But generally speaking, I think an arbitrator is a judge. And therefore, and I think that this is accepted, he should have a sort of immunity, except if he commits fraud, intentional negligence, or gross negligence. I think that should be the rule. It should not be different from the immunity granted to national judges.
BC, did you have a view on how arbitral institutes may hold particular arbitrators responsible or accountable for their actions in arbitral proceedings?
Good question. I think it has been the remedy when there is a breach of the obligation of the arbitrator. The seeking liability is has not been the principal remedy of it. Setting aside of the award, that would be ruining the reputation of the tribunal, or he or she will be not considered in future appointment, since the arbitrate institution has understanding that what happened, especially in connection with the obligation to continue to maintain impartiality, or failure to disclose, or obligation to complete their mandate. So those obligations could be receiving a lot of weight when the institutions are considering the arbitrator's performance. Thank you.
Elodie, would you comment on that, and perhaps whether arbitral institutions use the exclusion of an arbitrator from a panel as part of that accountability process?
Yes, I mean, one sanction, more or less official by institutions over the past few years, has been to act on the timing for the awards to be issued. And whether it's made official or not, effectively to reduce the fees to be paid to the arbitrators if, without legitimate reason, the award is taking too long to be issued. So that's been one area where the institutions have been in recent times more active. If you're talking about disclosure, independence, and partialities, the initiative has to come from the parties to challenge the arbitrator and to use a mechanism in the rules to deal with that. Exclusion of panel, I think it's pretty extreme. I don't know, if it may be well, a soft way of doing it is that the persons who don't get appointed again. And maybe when the panel comes from renewal, that person is not put again on the panel. An exclusion during the term on the panel, I mean, it may happen, but it would be pretty, extreme by the institution and really for a severe misconduct.
Thank you. Bernard, you spoke a moment ago about the role of an arbitral tribunal in facilitating a settlement by the parties of the dispute. A question has come in relation to what you spoke about in terms of providing provisional views of the tribunal to the parties, which might then be an aid to settlement. A concern raised is that if the parties do not settle, then that could provide material for the losing party to later challenge the tribunal based on a certain fixed view or at the extreme, a certain partiality towards one of the parties. Do you see a problem there?
Well, that's why if you enter into discussion with the parties, giving your provisional views or trying to assist them to reach a settlement, you must always have an undertaking by the parties that if they do not settle, they will never invoke the process in their post-hearing briefs or in subsequent submissions or in an action to set aside the award. And also they will not challenge the arbitrators on the basis of the fact that the arbitrators have made some proposals of settlement. This has to be done in writing. This is absolutely indispensable.
Elodie, I suppose another way to express what Bernard has said is that if the parties have consensually entered into this process where they've sought the provisional views of the arbitral tribunal, then it is not for them to complain after the fact. Would you agree with this approach?
Yes, I agree. And again, like you have really need to have safeguards, and especially if you're going to consider that process, you have to think about which are the jurisdiction involved, because more you have to think about the award being set aside, but also enforcement, and there are some jurisdictions where it may be a bit risky, even with something in writing, to be creative or to do things which would be unusual. But yeah, I think the parties, if you enter voluntarily in that process and you ask for the arbitrators' views, there is one shot out of two. Maybe that view is not going to be favorable, or you're not going to be happy with that view, and you have to live with it.
And BC, do you see that this role of the tribunal as facilitators of settlement or as amiable compositors is attractive to certain sectors of industry or certain geographical regions in the world where parties engage in arbitration?
I think, of course, to act as an amicable compositor, you need the consent of the parties under the modern law or Korean law as well. Whether in a specific industry, whether that gains traction. I'll say with the tradition of adjudication, so I think a construction area also that has a lot of the various claims. Then that's proper, and also especially Korean contractors, parties are aware that the arbitration could be pretty costly. Then I think that they seem to consider that kind of mediation as well at the early stage of the arbitration. So in that respect, I think also the mediation institutions in SIAC or other institutions are also gaining access or the consumers or relevant parties. Thank you.
Thank you. Bernard, in the few minutes that we have left in the event, I'd like to explore parties' choice of arbitrators. We've traversed a lot of ground, and the emphasis repeatedly is that tribunal members should be impartial, they should be fair. With everything that has been said, do you think that there's still a need for the parties to have the ability or the right to choose their arbitrator? And if so, what is the purpose of doing so if every arbitrator has the same duty to be impartial? Is it a question of an arbitrator having a cultural predisposition or a particular work ethic? What do you think remains to justify parties choosing their arbitrator?
Well, very, very good question. Let me say that I'm definitely in favor of parties having the right to appoint their arbitrator. I think it is a fundamental right of the parties. There have been proposals by various lawyers that in order to have a totally impartial tribunal, it should be appointed by an institution. By the way, and of course, you know, the role of an institution is not always easy, but I have had very bad experiences of, for example, chairman appointed by an institution, just the chairman. So chairman was a very good lawyer, but incapable of managing an arbitration. So I think that it is a right for the parties to appoint the arbitrator. So, for example, well, they know that this gentleman is a very good construction lawyer. For example, he's an English guy, he's an engineer and a lawyer. So they want to appoint him. He has a lot of experience. He has been involved in several hundreds construction arbitration. He has written a book on this. He is very conversant in both languages, you know, because the arbitration is in English, but there are some documents in French or in Spanish. You know, also he's very well known as a very independent guy. So I think that the parties know who they appoint, and today they are even more careful. You know, when I started arbitration, there were not too many arbitrations around. You just got a call saying, okay, we have decided to appoint you as arbitrator. Nowadays, you know, it's a very complex, very often a very complex process. So the parties know who they appoint, and I think it is extremely important.
BC, there's that view, and there's also the opposite view that henceforth arbitral institutions should be the ones appointing all three members of the tribunal. Would you care to speak to those two views?
Yes. So I think the party's appointment of arbitrators or nomination could give the impression that the arbitrators, although they have to be in principle independent, but the third party's perception-wise, that if they are repeatedly appointed by the same law firms or the parties, that could give the impression that they are not entirely neutral, or even if they have to have their appointing party's case to be fully better understood by the other member of the tribunal, if they make that efforts, that would be the situation. So under that scenario, the alternative view proposed is the young person, or that those the arbitrators as asserted that the three arbitrators should be appointed by institutions. But that was not that well received by the clients or the parties, because the charming point of arbitrator is to having arbitrators being appointed by the parties, and the companies or parties think that, oh, we can appoint at least one of them. That is an important factor. So I think I would add that given the increased responsibility of arbitration community, or given the important role of arbitration in global trade and investment, so I think that the institutions and the arbitrators, it is important to maintain a good reputation, and by performing all those obligations of arbitrators either under law of the contract theory or other conferred by law theory. So then I think given the importance, the public awareness on, they are watching us on whether we perform this obligation. So in that respect, institutions' role also are becoming more important. So it seems like, especially in treaty arbitrations, then ICSID, for example, has been looking on in those cases that has not been formally challenged or annulled. They are now deciding to look into the conflict issues or duty to disclose issue more strictly. So I think that is the way that this trend is going. So I think that is the institution's additional role we witnessed these days. Thank you.
Elodie, BC mentioned a moment ago a Jan Paulsen view. I'm going to ask you whether you, and we also spoke about accountability of arbitrators. I'm going to ask you whether you think that arbitration should develop its own appellate review, and whether that appellate review should go beyond just simple examination of due process, but go into things associated with the accountability that arbitrators must have.
Well, I mean, if we're talking in the commercial context, I think one of the appeal of arbitration is that you don't have an appeal on the merits. I don't really see like that. If you're talking about the accountability of arbitrators, and that can be dealt with through the set aside, like if the arbitrator wasn't, if it wasn't like discovered during the arbitration, and that the lack of independence of impartiality, there is a mechanism, like you don't need an appeal to deal with that. It can be through the set aside. And I'm skeptical about the benefit, because if you go through arbitration, you appoint your co-arbitrators, you have the arbitral tribunal, and do all of this to basically end up in front of a court of appeal, a national court of appeal, reviewing the whole case all over again. It kind of frustrates the purpose in the first place. And again, I'm talking about the commercial context, not the investment treaty arbitration context. So, so there are ways to deal with the accountability of arbitrators to the extent it needs to be addressed, which is, I mean, more the exception. It's quite rare, but there are ways to do it, and the system has a way to do it, which do not require adding a layer of national courts on top of it.
I feel I should put the same or similar question to Bernard. What do you think about international arbitration creating its own appellate review process? And if so, what should the scope of that appellate review be?
Well, in the commercial world, I would say no. Otherwise, you go to courts. But you know, one of the advantages of international arbitration, commercial arbitration, is that it is supposed to be, you know, a quick method of dispute settlement. So I don't see really the need for an appeal. In investment arbitration, the situation might be a bit different. There have been a lot of views in favor of having a second layer you know, a second layer, an appeal, a second level of arbitration. So there would be first award, and then the award would be reviewed, not as it is today by, you know, by a committee who decides whether there have been a breach of due process or principle of equality. So like, you know, the setting aside procedure, in other words. But there have been views that there should be an appeal. So far, nothing has been decided, but in that area, the question might be asked.
Bernard, in an arbitration, when the tribunal retires to consider its determination of the dispute, one of the arbitrators is at complete intellectual odds with the other two arbitrators. What, in your experience, happens normally? And if there is continuing lack of consensus, you have spoken about this earlier, about the desirability not to have a dissenting opinion, but some might say dissent is part of the arbitral discourse. I'd like you to share your views on this area.
Yes, as I said, I'm not in favor of dissents. And myself, I've just made 2 dissents in 2 cases where I was in total opposition with my co-arbitrators. You know, in 45 years of arbitration, I've done 2 dissents. So I'm not in favor of dissents. Well, I had the problem recently, you know, where obviously, of course, the dissenter had a different opinion, but I considered that the dissenter did not understand the problems, just a matter of understanding. So it was obvious from the beginning. I think in that case, we have not tried very much. We had some discussions, but it was obvious that the third arbitrator did not understand the legal issues. And for me, his dissenting opinion, because he issued a dissenting opinion, is totally wrong. But sometimes, of course, you can convince a dissenter not to issue a dissenting opinion, as I said, by just mentioning it is a majority decision, or mentioning in the body of the award, on this issue, the majority decided this, but one co-arbitrator considered that. And that's enough. Because, you know, dissenting opinion, they can fragilize an award. And I've seen cases, unfortunately, not many, but where the dissenter was really, to some extent, writing the request to set aside the award. Fortunately, lost.
BC, what do you think about the approach to a difference in views? Better to incorporate it into the main award and express the fact that there is a difference in views, or should the full dissenting view be set out perhaps in a separate document, either attached to the award or independent of itself?
So there is an issue whether a dissenting opinion can be the part of the arbitration award or not, right? So to the extent possible, it would be advisable that the dissenting view be reflected in the award. But if it is not allowed by the secretariat or by the majority of the arbitrators, then I think it is unavoidable that the dissenting opinion could be issued. But that whether there is an issue whether that is official part of the award or that kind of unofficial distribution of the dissenting opinion also is acceptable. So I think that which practice is preferable, it depends on the relationship between the 3 arbitrators. In some cases, that kind of unofficial distribution of dissenting opinion may be unavoidable, and that may even trigger the set-aside action. So I think that arbitration is a very flexible flexibility, or part of is the key characteristic. So I think that there would not be just one answer to that question. Thank you.
Thank you. And finally, Elodie, do you think dissent is part of healthy discourse?
I mean, dissent, difference of views, it's good to express them and to hopefully reconcile them for the award to the extent possible. I haven't had any, as an arbitrator, I haven't had any dissenting opinion on my tribunals yet. As counsel, I've only seen it once, and it was the scenario Bernard described. It was basically writing the application for set aside, which was otherwise, I think usually in a commercial case, I mean, it's different in investment treaty case where there are more like fundamental divergence on the law. Usually in a commercial case, it's assuming there is no biased arbitrator, it's possible to reconcile largely or fully views. And if the disagreements are on some points anyway, which wouldn't affect the outcome of the dispute, usually like the co-arbitrator won't insist in even putting a line because it doesn't change the outcome. If it's something more serious, there may be a line, but I think it's like working to make an enforceable award and not to affect or jeopardize the award unnecessarily.
Thank you all. Ladies and gentlemen, I hope you enjoyed this Maxwell conversation. Watch out for our next Maxwell conversation where we deal with another topic and challenge assumptions with a deeper examination of the issues. It remains for me to thank our speakers, Bernard Hanotiau, BC Yoon, and Elodie Dulac, and for me to wish you a good day from wherever you are watching. Good day.
Thank you very much, Laurence.
Thank
Thank you.